Reading the article when following the rules isn't sufficient. In today's immigration climate, you can be following the rules one day and the next day find your status is terminated. The fear and anxiety this creates makes it difficult for anyone to function from day to day. That's the point. The government wants you to feel so helpless and afraid that you will give up and self-deport. Most recently, these changes have impacted youth with special immigration juvenile status, or SIJS, and individuals with temporary protected status, or TPS, from Venezuela and Haiti. Individuals in these programs understood they were granted protection from removal. Now that status is threatened. It's critical that anyone with these circumstances try to access legal counsel. It is also important to find trusted sources of information. For instance, the National Immigration Project has a great youth hub in both English and Spanish, which provides information to keep those with SIJS informed. SIJS is a humanitarian immigration project that provides a pathway to lawful permanent residence for non-citizen children up to the age of 21 years who have been abused, neglected, or abandoned by their parents, and where a state juvenile court has determined that it is not in the child's best interest to be returned to their country of origin. Once a youth files a petition with the U.S. Citizenship and Immigration Services, USCIS, they must wait for approval. If the application is approved, they must wait for a visa, which is what can lead to permanent resident status. The problem is there is a limit to the number of these visas that can be issued in any one year and for any specific country. This has resulted in a significant backlog. And as a result of the backlog, the government in March of 2022 created the Deferred Action Policy. This meant that once a person was approved for SIJS, they had a 4-year renewable grant of deferred action if they lacked an available visa due to the visa backlog. Also, once you receive a grant of deferred action, you can apply to receive a work permit. On June 6th of 2025, the government terminated the deferred action policy for youth with SIJS. However, just because the government terminates SIJS status doesn't mean that it's legal. Often, it's the start of a legal battle. For instance, about a month after the government's termination, a class action lawsuit was filed challenging the decision and seeking an injunction. An injunction would stop the government from terminating the deferred action policy. There was a hearing for the case in early September. The judge is waiting for additional information from both parties, and a ruling is possible by the end of September. The government will likely appeal any ruling favorable to those with SIJS, so the battle will likely continue into next year. However, the hope is that at least for the time being, your status would be protected. Theoretically, you should retain your deferred action status until it expires. Although the USCIS can still terminate a deferred action grant at any time, this is most likely to occur if an individual faces criminal charges or gang allegations. Also critical is that once your deferred action expires or terminates, you lose the ability to work. If you are in this category, it is crucial for you to reconnect with your legal counsel to determine your risk and best course of action. Your attorney may want to consider your eligibility for additional forms of immigration status. Temporary protected status. On February 5th of this year, the Department of Homeland Security, or DHS, terminated protections for about 350,000 Venezuelans under the 2023 designation, which overturned a decision by the Biden administration to extend protections until October 2nd of 2026. On July 1st, DHS announced it would terminate TPS protection for about 250,000 Haitians with an effective termination date of September 2nd, 2025. The Biden administration had extended protections for Haitians to February 5th, 2026. On September 5th, a federal judge in California ruled that the Trump administration improperly stripped TPS from these immigrants. In a 69-page opinion, the judge stated that the terminations were unlawful because they bypassed required legal procedures, including proper interagency consultation and analysis of country conditions. For now, the ruling preserves Venezuelan and Haitians TPS holders' ability to remain in the United States, work legally, and avoid deportation while litigation continues. However, the Trump administration has already filed a motion to stay the judge's ruling pending approval. Denial of asylum applications. Another issue to be vigilant about is for those seeking asylum. In a policy memo the government issued in April of 2025, immigration judges are encouraged to deny asylum applications without due process if the application is considered incomplete. An incomplete application is one that does not include a response to each question, is unsigned, or is unaccompanied by the required materials. This guidance to judges is despite the fact that the regulations provide that anyone submitting an incomplete application should have the opportunity to correct the error and resubmit. The administration's policy memo is not supported by the authority on which it relies, and the arbitrary rejection of asylum applications violates long-standing law and practice. This is resulting in a variety of responses from immigration judges. This is an issue for which lawyers are struggling to ensure they are using all possible tools to avoid outright rejection for their clients. However, the most egregious situations are those in which those affected don't have legal counsel. Therefore, those without representation are most at risk and those most likely to be deported. The issues discussed here raise the question of how anyone can navigate all these abrupt policy changes resulting in termination of status, legal changes that are legal challenges that are wins one day and losses the next, and aggressive immigration judges denying asylum. You have tried to follow the rules, yet you still find yourself in jeopardy. Although it is not easy, try not to despair. You exhibited incredible courage initially in coming to this country. Now you need to find that courage once again to fight for what is right. This is your country too. The best thing you can do is obtain legal assistance. Legal resources are scarce, but options are still available. For additional help, please reach out to indivisible845.immigration@gmail.com. Thank you.